Imagine this. You apply for a U.S. visa, and before a consular officer even looks at your documents, they are already scrolling through your Twitter, your Instagram, your Facebook, every post, every comment, every like. That is not a hypothetical anymore. Right now, over 1.2 million visa applicants, including H1B workers, F1 students, J1 exchange visitors, and their family dependents, are subject to mandatory social media vetting by the U.S. Department of State. If you are planning to apply for a U.S. visa, or you already have one, you need to watch this entire video. What you don't know could cost you your visa. Welcome to Global Immigration Scope, your trusted source for clear, accurate, and timely immigration news from around the world. I'm your host, and today we're covering one of the most significant changes to U.S. visa policy in recent years. The U.S. Department of State, the official authority that manages visa approvals for the United States, has rolled out a sweeping expansion of its online presence review policy. This update has been confirmed through official announcements published directly on travel.state.gov and supported by guidance from USCIS, the U.S. Citizenship and Immigration Services. This is not a rumor. This is not speculation. This is official U.S. government policy, and it is already in effect. Let's break it all down. What happened? The United States government has expanded its social media screening program to cover a wide range of non-immigrant visa categories. Here is the timeline of events. June 18, 2025. The Department of State first announced that F visa student, M visa vocational student, and J visa exchange visitor applicants would be required to make all their social media profiles public and submit them for review as part of the visa application process. December 3, 2025. The State Department announced a major expansion, extending the same requirement to H1B visa applicants, skilled foreign workers, and their H4 dependent family members. December 15, 2025. This expanded policy officially went into effect. Why did this happen? The State Department's official stance is straightforward: national security and public safety. In the words of the official announcement, and I quote, "Every visa adjudication is a national security decision." The government wants to identify applicants who may pose a threat to U.S. citizens, institutions, or national interests. Social media, they argue, provides a real-time window into a person's beliefs, associations, and intentions. Additionally, a November 2025 attack on National Guard members in Washington, D.C. is cited as a trigger that accelerated these expanded vetting measures. When did it take effect? For F, M, and J visa applicants, June 18, 2025. For H1B and H4 applicants, December 15, 2025. Both policies are currently active. Who is affected? This policy covers H1B visa holders, skilled workers, mostly in technology, engineering, healthcare, and finance. H4 visa holders, spouses and children of H1B workers, F1 visa holders, international students at U.S. colleges and universities, F2 dependents, family members of F1 students, J1 exchange visitors, researchers, scholars, and cultural exchange participants. J2 dependents, family of J1 holders, M visa holders, vocational and technical school students. When you add all of these categories together, immigration experts estimate that over 1.2 million applicants annually fall under this new vetting requirement. Let's go deeper. Here are the key rules and requirements every applicant must understand. Rule number 1. Make all social media profiles public. This is not optional. You are required to set every social media account to public before your visa interview and for the duration of the application process. This includes Facebook, Instagram, X, formerly Twitter, TikTok, YouTube, LinkedIn, and any other platform you use. Rule number 2. Disclose all accounts used in the past 5 years. You must list every social media handle and platform you have used in the last 5 years on your visa application forms. Failing to disclose an account, even an inactive one, can be treated as misrepresentation, which is a serious immigration violation. Rule number 3, do not delete your accounts. This is critical. Legal experts strongly advise applicants not to suddenly delete or deactivate accounts close to their interview date. U.S. consular officers and reportedly artificial intelligence systems are used to flag unusual account behavior. Sudden deletions can raise red flags and make officers suspicious. What are consular officers looking for? Alert. Based on official guidance and legal sources, here is what they screen for: indications of hostility toward the United States, its government, citizens, or founding principles. Affiliation with or support for designated terrorist organizations. Content expressing threats or harassment toward U.S. individuals or institutions. Evidence of planned illegal activities. Anti-Semitic content, hate speech, or extremist ideology. USCIS has explicitly stated this is a negative factor in any immigration benefit decision. Mismatches between your social media profile and your visa application. For example, if your LinkedIn shows a different employer or job title than what is listed on your H1B petition, LinkedIn gets special attention. For H1B applicants specifically, consular officers are instructed to cross-check LinkedIn and other professional profiles for consistency with petition details, including job title, employer name, work start dates, and job duties. So what does all of this mean in practice? Let's talk about real-world impact. Impact number 1, longer processing times. This is the most immediate concern. Social media review takes time, especially now that hundreds of thousands of applicants are subject to it. Legal experts across multiple immigration law firms are warning that visa stamping timelines will increase, and administrative processing delays, where your application is placed on hold pending additional review, will become more common. If you are traveling to a U.S. consulate for a visa stamp, build extra time into your schedule. Project deadlines, university enrollment dates, and travel plans may all be affected. Impact number 2, greater risk of visa. Denial private profiles, missing accounts, or social media content that consular officers find concerning can lead directly to a visa refusal. The policy is clear. Unavailable profiles may trigger negative credibility inferences, meaning the officer may assume you are hiding something. Impact number 3, impact on employers. For U.S. companies that sponsor H1B workers, this creates workforce mobility challenges. If an employee needs to travel internationally and return to the U.S. on a renewed visa stamp, the added vetting time can disrupt project timelines and business operations. Impact number 4, privacy concerns. Civil liberties organizations, including the Brennan Center for Justice, have raised serious concerns about this policy. They argue that requiring applicants to make their private social media profiles public, under government pressure, raises significant First Amendment and privacy issues. The government has not clearly defined what content crosses the line from protected speech to a national security concern, which creates uncertainty for applicants. Impact EI5, potential benefits, government perspective. From the government standpoint, this policy is designed to create a safer visa process. Officials argue that it helps identify individuals who may have misrepresented their intentions or pose genuine security risks, and that for the majority of honest, law-abiding applicants, it simply confirms what their documents already show. Looking ahead, what can we expect? The policy will likely expand. Further, U.S. Customs and Border Protection, that is CBP, has proposed requiring social media history for ESTA applicants as well. ESTA is the visa waiver program used by travelers from 42 countries. A 60-day public comment period closed in February 2026, and further rulemaking is expected. If this passes, even visa-exempt travelers entering the United States could face social media checks. Artificial intelligence will play a bigger role. USCIS has stated that its newly established vetting center will use state-of-the-art AI technologies to conduct these reviews. As AI tools become more sophisticated, the speed and depth of social media screening will only increase. More visa categories could be added. Currently, the policy formally covers H1B, H4, F, M, and J visa categories. But legal analysts believe there is nothing stopping the administration from extending these requirements to L1, O1, EB series green card applicants and others in future rulemaking. Global trend. The United States is not alone. Several other countries are also exploring or implementing digital vetting of visa applicants. This reflects a global shift toward using social media as a background check tool in immigration processes. The bottom line: social media is now a permanent and growing part of the U.S. visa process. Applicants who ignore this reality do so at their own risk. Let me quickly summarize what we covered today. The U.S. Department of State has expanded mandatory social media vetting to over 1.2 million visa applicants annually, including H1B workers, H4 dependents, F1 students, and J1 exchange visitors. All affected applicants must 1. Set all social media profiles to public. 2. Disclose all accounts used in the past 5 years. 3. Avoid suddenly deleting accounts before interviews. 4. Ensure their online profiles match their visa application details. If you are applying for a U.S. visa, review your social media carefully and consider consulting an immigration attorney for guidance. This is a fast-moving area of immigration law, and staying informed is your best protection. Thank you for watching Global Immigration Scope. Stay informed and subscribe for the latest immigration news and visa updates from around the world.